Well, the public has until the end of the month to comment on the expropriation bill. It will allow government to redistribute land in the country to attain transformation. But there are several concerns around the process and how the bill will actually achieve this. Well, we're talking this morning to Ruth Hall. She's from the Institute for Poverty, Land and Agrarian Studies. Good morning, Ruth, and thanks so much for your time. And before we head to our chat, I quickly want to play you this comment from the Institute of Race Relations. Now, it says that this bill must be stopped. It says the bill does not stop at land and can be used to grab property, assets and even mining rights. Let's take a listen.
In essence, I think there are four problems with the bill of a very major kind. And the first is that it doesn't deal only with land, and particularly not just with farmland, as many people think. The bill defines property as not limited to land, so it could extend to any number of other assets, from shares in the South African Reserve Bank to mining rights, pension rights and so on. Secondly, it allows for nil compensation on expropriation in certain circumstances, but it's entirely unclear as to what those circumstances are. Often the tests laid down are very vague, but beyond that, the list which is provided is expressly not a closed list. In other words, officials and municipalities will be able to decide that other circumstances should also merit nil compensation. And though people might have a right to go to court to contest that, that will be difficult, because the third problem with the bill is that the procedures it sets up are vastly skewed in favour of the state. So if a municipality wants to expropriate, say, land for a housing development, it has to go through some simple preliminary steps, and then it can expropriate simply by serving a document, a notice of expropriation on the owner. And under that notice, the right to ownership will automatically pass to the municipality, irrespective of any dispute, by operation of law on the date set in the notice, which could be very soon. It could be a day or a week or a fortnight later. The only limit in the bill is that the ownership can't pass before the service of the notice of expropriation.
All right, Ruth. Well, you support the bill, but you also have several of your own concerns. And I'd like you to expand on what you were worried about and whether you think that the Institute also has some valid points there.
Thanks so much for the opportunity to comment. Firstly, we must be very clear that this bill is needed, and the reason why it's needed is that ever since we adopted our new constitution in 1996, there's been a contradiction between what the constitution says can happen and what our law says. So we have an expropriation bill dating from an expropriation act that dates from 1975. It's an apartheid era bill, and it says when the state expropriates, it has to always pay market-related compensation, and it says that it can only expropriate for public purposes. And that would exclude, for instance, where land is being claimed for restitution. So these things were negotiated in the course of our transition in the 1990s, and what this bill is doing is it's bringing our law in line with our constitution. There has been a contradiction for the past 25 years. So that's the first thing I'd say. Secondly, I disagree on the actual substance of the Institute of Race Relations argument. There's a 7-stage process that's set out in the bill. The state has to serve a notice of expropriation. There are 30 days for an owner to respond to say if they object, what compensation they want. And if there's anyone else who will be affected by this, there's a further 20 days for government to say if it accepts or rejects. Then there's another 40 days for the owner to say whether they agree with government's approach. Then government has to publish this in a gazette. Then people can accept or reject. And then they have a further 180 days after all of these processes that add up to about a year. They have a further 180 days in which they can contest that in court. So actually, I think, if anything, this gives enormous opportunity for property owners to state their case and to be heard. One thing, though, that I would say is that, if anything, some of these notice periods are short. And the reason why I raise this as a concern is not that a wealthy property owner couldn't respond. They have ample opportunity to do so. But if we look at some of these periods, like 20 to 30 days, my only concern is that the state sometimes expropriates rural communities, people living on customary land. And so how this will operate in that context is a concern. So I disagree with the substance of the Institute of Race Relations. Secondly, I'd emphasize that it's necessary. this bill.
Well, Ruth, there's also a lot of concern around the possible abuse of expropriation as well. I'd just like your thoughts on that. And also, whether we are carrying out a proper public interest test, and we know that there's a limited time now for the public to go out and comment on this, and whether we have been carrying out a proper public interest test.
Actually, I would turn the question around. So from 1996, the Constitution has said that the state may expropriate for public purposes and in the public interest. It needs to pay just and equitable compensation, which theoretically could be set at zero if it's just and equitable. And for all this time, that hasn't been happening. And so what I would say is that actually this process has been drawn out. The first bill was published in 2008. The Institute of Race Relations, various political parties and interest groups slammed it. It was withdrawn. It came back again several times. It came back in 2015, in 2018, in 2019, and 2020. So, if anything, there has been a problem of justice delayed in this case. Let me make it clear, though, that expropriation is a standard state activity. Around the world, states have a power of eminent domain. These rights are constrained by laws of natural justice, by procedural and administrative law. Is this action reasonable, etc.? And so all of this is subject to that. I think the key problem here is not that it gives the power, unfettered power to the state. If anything, the state has very clear constraints placed upon it. My concern is that the state hasn't said in clear political terms, here's how we want to use these powers. So the state hasn't said how it's going to approach expropriation. And the reality is that there are a few cases where no compensation could be paid that are mentioned in the bill. But these are very few and far between. If the property is held purely for speculation, if it was acquired through illegal means, if the state has already subsidized it so heavily it shouldn't pay any further. These are very few cases. So I think that a key question is, how does the state want to approach compensation? That's a political question. And our Presidential Advisory Panel on Land Reform advised that, in fact, a compensation policy should be developed where the state sets out how it's going to approach what is just and equitable. And that should actually be appended to the bill as regulations. And that hasn't happened. So we don't really know how the state wants to approach compensation. What I would say is that this bill has very clear processes and procedures. It very clearly has this iterative process of the state stating its case and owners being able to respond, which I think is it sets out a very elaborate process, which will clearly give ample opportunity for individual property owners to state their case. I think that the complexity comes in with the fact that actually most of the time when the state expropriates, as it often does, not for land reform purposes, it's expropriating poor people, often Black South Africans who live in informal settlements, in communal areas. This is where the state is mostly expropriating. So how will those people be able to effectively defend their rights, I think is a key question. I think that the processes that the bill sets out are more than adequate. There's one additional point that the Institute of Race Relations raised, which is, of course, this bill is about the state expropriating property, not only land. And that's correct. The Constitution, in fact, has a property clause that applies to all property. So our constitutional framework and indeed our expropriation laws have always pertained to property. And whether or not different rules or different approaches to compensation are developed for land versus other property will be worked out through the process and through the courts. But indeed it is right that our Constitution addresses property and that land is not treated as a different category of property.
Well, certainly a long road ahead. Thanks very much for breaking that down for us, Ruth Hall there.